This is the Resilient Advisor Podcast, the show for high-performing financial advisors. We bring you the best practices of the industry's top performers so that you can build resilience in your business and your personal life. Here is your host, Jay Coulter.
Thanks for downloading this episode of the Resilient Advisor Podcast. This episode is sponsored by my consulting firm, R.C. Whatley. At R.C. Whatley, we help financial advisors grow their business by building and implementing customized systems that create the capacity for growth. For more information, please visit rcwhatley.com. Now, our firm, by design, does not provide any type of recruiting services, as that would just be a conflict of interest. But, as you might imagine, we do get asked about the challenges an advisor or team may face if they were to break away from their firm and go independent. Joining me today is attorney Joel Beck of the Beck Law Firm. Joel's practice is focused in the areas of financial markets, insurance regulation, estate planning, and business law, and this is a topic that's right on point for him. On this episode, we're going to discuss the legal and compliance issues to consider if you're thinking about going independent. Joel, thanks for coming on the podcast.
Thanks for having me, Jay. Happy to be here to talk with you about this topic today.
All right, well, let's jump right in. Let's start with why financial advisors always think the grass is greener on the other side.
Well, most of the times I think they do when they're looking at a change. Maybe they're not quite happy with a payout. Maybe they're not quite happy with a management or a compliance or supervision structure. Perhaps they want some more freedom in choosing the product mix available to them, or they just want to be their own boss and have more control over their own business. From a lot of perspectives. So I think those are some reasons why advisors may think that the grass is always greener, but it isn't always. And that's what I think advisors have to be careful about. You've got to look beyond just simply a higher payout. When looking at making a move and going independent, look beyond just the bump up in payout. Consider what your expenses will be and what you'll have to cover. Think about how you're going to handle management, supervision, compliance issues, as well as the product mix that you will get. And of course, sometimes making a move can be a very positive thing, but make sure that if you're thinking about making a change, that you've really vetted the idea before you jump the fence for what may not turn out to be greener pastures. And along those lines, if you are going to jump the fence and you're being promised something that's really important to you by a firm, and you want to make sure that that promise is going to be kept, then by all means, make sure you get it in writing.
Have you seen advisors that have engaged you and they're pretty far down the process, they've been promised a bunch of things by a firm and they don't have it in writing and then it doesn't work out for them?
Well, usually, Jay, what happens is they'll come to me after the fact when they were promised certain things to make a move, and those action items don't materialize. And then we're left without many options many times to resolve the dilemma because the firm is now not agreeing to that. We have no evidence, we have no contractual obligations for the firm to provide whatever it is. Maybe it's certain back office or in-house administrative support or something else, access to particular products. Without getting that in writing at the time of the recruiting and the transition, we're often left without the ability to prove that promise was made and then to be able to enforce it.
Yeah, the key lesson there, everything needs to be in writing on the front end or else you don't have a claim to it, correct?
Absolutely. That's right.
All right, so if you're starting a firm, if you're thinking of breaking away from, say, a wirehouse, going completely independent, there are other things that need to be considered with regards to running a business. Could you touch on that and specifically things that advisors probably don't think about or spend enough time thinking about pre-move?
Yeah, that's a great question. And I think it's touches on an area that a lot of folks don't really focus on and think ahead about. When you're working at a wirehouse, your business structure is set for you. Generally speaking, the back office and operations people are there. You've got a big group somewhere that handles HR issues and certain compliance issues, even things like getting a copy machine in the office, phone lines and things like that. And if you go out on your own, whether you're starting your own RIA or moving to an independent broker dealer or what have you, or doing both of those things, you are now going to become more than a financial advisor. You're going to become an entrepreneur, and you're going to have to plan and act accordingly. It's now going to be incumbent upon you to get some office telephones, right? To handle postage, to hire staff, and a big one, to train staff, and then in some cases to fire staff. And so your roles, your duties expand greatly beyond just serving clients, beyond growing clients' assets, growing assets under management and serving those. You are now going to wear a whole lot of different hats that you probably didn't have to even think about putting on when you were at the wirehouse. So you've got to really expand your thought of what your roles and duties and responsibilities are going to be when you make that move to go independent.
Yeah, that's interesting because when we're brought in a consulting engagement for an independent firm that has just left in the previous year, the number one issue that we have to take care of on the front end is human resources, staff problems that were created because they just weren't experienced in putting the right people in the right places. So that makes a lot of sense. Now, in my experience,
and beyond that, I'm sorry.
No,
but
please.
Beyond that, it's not just getting those people in place, but it's developing the systems and the procedures internally to make those people work efficiently. And I'm sure that's where, you and the team at R.C. Watley help advisors in implementing those systems so that staff are following one way of doing things to ensure a clear and consistent approach in handling that client business, from the intake and onboarding process to the investment management and the other day-to-day stuff.
Boy, that's exactly right. And I tell you, speaking of systems, the systems that most advisors least enjoy working on are their compliance systems because it's been taking care of them before they break away. Could you touch on the issues surrounding that for these breakaway advisors?
Absolutely. So, Jay, if you've got an advisor who's starting his or her own RIA firm, they're going to have in place a compliance system, a set of written supervisory procedures, compliance manual, and they're also going to have a code of ethics for that firm. And they're going to have to put that together. And, a benefit of starting your own firm may be getting away from what you think is a burdensome compliance program from where you are now. But the reality is you have to have a robust compliance program at your firm as well if you're independent, together with some risk management policies and procedures so that you help protect your business, protect your reputation from liabilities and claims in the event that things go wrong, that staff don't act in a way that they should. So compliance is important, whether you're at a wirehouse, whether you're at an independent broker dealer or starting your own RIA. You can't overlook compliance, and you can't have the mindset that just because you're going out on your own, you can do everything your way. You simply can't. You still have to follow the rules and the regs.
Joel, could we go a little bit deeper on that and get granular with these hybrid setups where they have a broker-dealer and a broker-dealer compliance department and then the RIA where they run I'm assuming, a different set of compliance rules? And does that give them a choice as to which set of rules to follow in different situations?
Well, not necessarily, because they're going to have to follow their systems and procedures all the time. So, for example, when you're with an independent model broker dealer, and you are a registered representative, you don't get to take that hat off, that registered rep hat off, and put it aside to go do something else. If you're a registered rep, the rules for the broker-dealer industry always apply, and you're going to have to follow those. And even though you're doing business on the RIA side, in your own RIA, your broker-dealer is going to want to monitor, to an extent, that business and that activity because they have a regulatory obligation to do so. And so you won't be able to just say, shield certain activities of yours from scrutiny by the broker-dealer. They're going to definitely overlap. And so there is always going to be a high level of compliance necessary. And to an extent, that's good because you want to be running a clean shop, a compliant shop, because that's going to avoid problems and hassles with regulators. It's going to avoid problems with your independent broker-dealer with their compliance department and management, and it's going to help you minimize risk and reduce your exposure to claims from your clients.
Is it fair to say that you're actually adding more complexity by being a hybrid advisor?
Yeah, I think that it is. Now, it doesn't have to be a burden, though, at least an unwieldy or an unmanageable burden. But think about it. If you're just at a wirehouse or just at a broker-dealer and all you're doing is registered rep work and you're not involved in RIA-type business, you're only subject to the industry rules for broker-dealers. So the SEC rules and regs, FINRA's rules, and then the rules of the various states where you do business. When you then go hybrid and you are working both as a registered rep of a broker-dealer and as an IAR, an investment advisor rep of a registered investment advisor, now you're going to be subjecting yourself to the regulatory schemes of two industries, that of the broker-dealer and of the RIA. So it does become a little more difficult, but it's workable, it's manageable. And there are certainly ways that you can get help to set in place good basic compliance systems and procedures for your RIA for you to follow. And then your broker-dealer will help you understand what you need to do from their end to comply on the broker-dealer side.
Gotcha. Let's talk a little bit about protocol, because I think there's a lot of misunderstanding in the marketplace about exactly what protections you have with protocol, and it seems to be evolving as well. What are your thoughts on the process today?
Well, when we talk about protocol, and I think here you're talking about the protocol for broker recruiting, this applies only on the broker-dealer side, okay? And it only applies to firms and representatives of firms who are signatories to this recruiting protocol. And the genesis behind this was the big firms got together and wanted to find a way to allow reps to move from firm to firm when appropriate and take limited information and to reduce the firms suing each other for competitive reasons. And so under the broker protocol, when a broker leaves a firm that is a signatory to the protocol to go to another firm that's also a signatory, then that broker is able to take certain information about his or her clients, such as a name, an account title, not the account number, and certain contact information for that client. And they do so in accordance with how the protocol spells this out. And if they act in accordance with the protocol, then they're not going to be sued, and their firm is not going to be sued for actions that are subject to the protocol. And so that helps facilitate advisors moving from one broker-dealer to another when they're both signatories. But there's some issues here that I think advisors don't realize, and those primarily relate to a misunderstanding of what type of information they can take and what they can do with it. Importantly, advisors have to recognize that they can't take all of the information that they might like to, because the rules and regulations still apply. Regulation SP from the SEC still requires that firms and representatives keep confidential certain non-public client information. And so they can't just take that, especially without the consent of a client, to another firm. That's a violation of Reg SP. But beyond that, advisors, I think, sometimes think that the clients are theirs and they can do with it what they want and take all this information, even when a firm that they're going to is not a signatory to the protocol. And again, that's just not the case. So if you're looking at making a transition and you have questions about what information you can take and how that process works, the time to ask some questions and to get some guidance is before you make the move. And if you do that, you're going to avoid a lot of these pitfalls that advisors find themselves in. And it's going to make the transition process go a lot more smoothly for you and your clients.
So for that transition, the advisor is going to need to also pay attention to their U4 and their CRD as well. Could you touch on that a little bit, and specifically what they need to do prior to a move?
Sure. Well, one of the things I suggest is whether you're going to make a move or not, once or twice a year, you need to be looking at your CRD record and making sure that the information in there is accurate and up to date. And of course, advisors should know that if something comes up during the year that would require them to update their U4, they need to go ahead and do that immediately. In fact, they generally have 30 days from the date of the event to update their U4. In some situations, though, they only have 10 days. But so you can't wait until the next time that you complete that annual compliance questionnaire necessarily to update the U4. You need to do that. But back to your question, you've got to make sure that the information in CRD is accurate, because when you go talk to some other firms about joining them and making a move, whether it's to go from one wirehouse to another or to go independent, that other firm is going to have you sign a release so they can check your CRD. And then they're going to be able to see everything that's in there. You need to know what they're going to see. You need to make sure that what they see is accurate, that it's up to date, that you have treated it properly, that if you ought to have some type of explanation in the CRD system about a matter, that you've got it in there and that it's worded right and reads well. So you've got to do this before you begin making a move or trying to do that. And then understand as well that a lot of this information in CRD, if you go into the RIA world, then that's going to flow through onto your Form ADV and your brochure for all of your clients and prospects to see when you have to send this to them each year. So making sure that the information in CRD and on your U4 is accurate is going to be helpful. One area, though, as we talk about the U4, a problem area for advisors is when they have failed to keep their U4 current, then they run the risk of getting found out when they look to make a move. For example, maybe they've got some unsatisfied liens or judgments against them, or they've been charged or convicted of certain reportable criminal matters, and they've not put that on their U4. Well, maybe Nobody has discovered it yet. But now, when they look to join a new firm, that new firm is going to do a more exhaustive background check on them now than several years ago. And it may be that this is going to turn up, and that may cause problems. Moreover, if you do report something new when you join a new firm, and you put something new on the U4, that may trigger a review by the states, and that can delay your ability to get up and registered with those states, and then therefore that delays your ability to transfer clients' accounts from your old firm to the new firm. So getting your disclosures and your U4 and your CRD records squared away before you make a transition, I think is just really critical.
You know, the legal and compliance issues surrounding running a practice and a move sometimes seems like a big old bowl of, letter and number soup here. Tell me a little bit about U5 issues and how they could affect somebody as they were looking to make a move.
Sure. So we talk about U4 and U5, and all this is the way that things get reported to the regulators and into the CRD system. The U4 is what you fill out to be registered and to stay registered with a firm. When you leave a firm, the firm completes a U5. It's their form, and they file it with FINRA and the other and the states through the CRD system. And what the U5 does, Jay, is it tells the regulators, it tells the states, and conceivably tells the public that this advisor is no longer at this firm. They left on such and such date under such and such circumstances. And so if you look at a U5 form, what you'll see is a firm has to disclose whether at the time the advisor left, whether he or she was under an internal review, whether they were discharged or left voluntarily or were permitted to resign. They also have to disclose whether there was any formal regulatory investigation at the time that the advisor left. And then they also have to disclose if the advisor was terminated amidst allegations of some type of impropriety, such as a violation of industry rules and regulations or even industry standards of conduct, which would be interpreted as violating the firm's own internal policies and procedures. So the U5 gives a lot of information to regulators. Some of that flows through into the publicly available broker check system. And the U5 filings may trigger a regulatory exam by FINRA, and it may also trigger a more high-level scrutiny by the states if you try to get registered again with another firm in the future. So making sure that your U5 is as clean as possible when you leave a firm is really important. Just that simple.
Joel, this has been incredibly valuable information for anybody looking to make a move. Before we wrap up, do you have any final thoughts?
Well, Jay, I think that if you're looking to make a move, if you're an advisor looking to make a move, whether you're going to go independent, whether you're going to start your own RIA, but you're making a big change, treat it as a big change. Get help on the front end so that you understand what you need to do to set yourself up for success. And take some time, if you have it, to plan appropriately so that your transition, and then therefore the transition of your clients, can be as smooth and successful as possible. And then you're going to want, I think, to surround yourself with some good professionals. You may need a good compliance consultant, especially if you're starting your own RIA. You'll need a good financial markets regulation attorney to help guide you through the process, a CPA or tax advisor as well, maybe a practice coach like you or somebody else at R.C. Watley to help plan for this and to develop those systems and procedures to help you run your business. Again, it goes back earlier, Jay, we talked about wearing a lot more hats when you're independent, and you've really just got to plan for that. I think a lot of advisors who break away and start their own shop they find wearing all of these hats challenging, but they also find the whole process encouraging and fun. And they like the freedoms and joy that it can bring. But you're going to have a lot more roles and responsibilities beyond just being a financial advisor at your firm. And of course, that's challenging enough. But now when you tack these things, these other things on, get the right people around you to help you succeed. And I think you're going to find that your life and your practice will be more fun and more successful.
Fantastic, Joel. Thank you so much for your time today. And how can our listeners find out more information about you and your firm?
Sure, great, and thanks. You can just find us online at thebeckfirm.com or give us a call at our office at 678-344-5342. Thanks for having us, Jay.
I'll have links to everything in our show notes. Thanks again, Joel.